Alex here with part 44 of the My Docket series on child custody and visitation. I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. The two things that I will glaze over very quickly are, number 1, I am not in the middle of this right now. My case is completely and totally over. It's closed. My ex's parental rights have been terminated. Number 2, the underlying purpose of the series is to give my viewers one giant example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We left off in part 43 with the conflict between myself and my ex, well, more specifically her attorney. We left off in part 42 with a little bit more, well, at least with respect to what I'm going to cover in this video, with a little bit more relevant, I guess you could say, history. That was the initial pleading in the case that I brought against the government, more specifically the Secretary of State. So we lead off here with the Secretary of State's response, which is a little odd. I'm not going to say their response was odd. I'm going to say the way I dealt with it was odd, and it didn't end up backfiring on me, but it could have, and quite frankly, it should have, with the response that the Secretary of State gave being strictly technical and procedural, and with the way in which I pretty much guess the Supreme Court would have dealt with it had the judge sided with me and entered default against him. The judge didn't side with me or with them. He ended up finding a middle ground, and because it was such an ancillary order, like it wasn't really, all he did was just direct responses to be filed. I'm going to go ahead and lump that into this video. I'm saying that because usually that's not what I do. Usually I will give a court's order its own separate video. I don't usually just roll it in with some other stuff that's come up. But that's really what I'm going to do in this case, because the order itself didn't do anything substantial. It just ordered both sides to start filing briefs, and that was it. And I think I made it clear, but just in case I didn't, I do think that the judge should have sided with the Secretary of State on this, and I do think that I should have abided by the statutes and the procedure that was required. However, that didn't happen. I'll talk a little bit more about it in the portion of the video where I go over the documents, just so I make it a little bit more clear. Specifically what I mean by siding with the Secretary. I'm going to go through their letter and explain why they're right and why it's important for my viewers to do something like this and to not just kind of wing it and hope that the judge is going to cut you some breaks because you're representing yourself, which is kind of what I feel happened in this situation. And I think at this point we can go ahead and take a look at what the Secretary of State has filed. Here we have the letter from the Secretary of State. I think that this initial document here, I think this is something that the clerks attach to a filing. Well, it's not really a filing, that's why they do this. When they get like a document from somebody, typically a letter, and they need to file into a case, I think this is something that they just attach as page 1 of the filing. And I imagine that it's probably something that happens a lot in probate cases when they get letters from potential heirs, or like when they get a letter from a witness and that witness is wondering how they're supposed to do something. Like maybe they're like 4 states away and they don't think it's fair that they have to go, across the country to go to a hearing, and so they send a letter to the court. Typically people who just don't know how to communicate with the court, and so they communicate by a letter, which is how they communicate with other people. It's a little odd that the Secretary of State did this, or I guess it would be actually the Attorney General, that they would just send a letter to the court and not file something more formal, but that's what they did. So I'm going to scroll down, and it is here's a letter from the Attorney General that they received and filed. The first thing that I notice is they are stating there is a statute, NRS 41.031, that applies. This is a statute I think I was talking about in part 42 that mentions that when you sue the government, in this particular case, the Secretary of State, that you have to serve both the Secretary of State and the Attorney General's office, that you can't just serve one or the other. And I'm not going to double check it. I'm like 99% sure that's the statute that I was talking about earlier. But if you have any questions about that, you can definitely take a look for yourself and post something down in the comments below if it doesn't seem to apply or if it's odd. The next sentence here states that once I do effect service on the Attorney General's office as required by law, they intend to respond appropriately to the lawsuit. So this is kind of like their non-response response. They're responding to me and communicating with court that they aren't going to respond because they haven't been served appropriately under the law. Now, 3 or 4 years ago, I would have probably laughed at this and said that they were playing games, and I guess in a way they are. But one thing that I kind of take into consideration now that I don't take into consideration then is what would the Supreme Court say? And I have a bad feeling that the Supreme Court would consider this to be a meritorious argument, and had I won this lawsuit and they use this against me, I don't doubt that I would have lost the appeal, because service of process is a jurisdictional issue, and if jurisdiction is not properly in place, the Supreme Court takes it very seriously. They will overturn decisions where jurisdiction was not properly taken care of. And I've mentioned how when you file the initial pleading, you submit yourself to the jurisdiction of the court. But everyone else that's a target of your lawsuit, the court needs you to do certain things so that jurisdiction can be imposed on them. It's not often that a target to a lawsuit will consent or submit themselves to the jurisdiction of the court. Typically, other parties will expect you to have jurisdiction imposed on them by following all of the rules that are required under, you could say statutory, and when it comes to the government, you're looking at due process. And service of process is a very serious thing when it comes to making sure that a person is properly under the jurisdiction of the court, just like you are. You've submitted yourself to the court's jurisdiction, and you need to make sure that all the targets of your lawsuit are also properly under the jurisdiction of the court before you get started on the suit itself. So this is something that ends up working out in my favor, but I'm not convinced that that was the right action that the court took. And I'm also not convinced that I would have won an appeal had I ultimately won this case anyway. So I do want to tell my viewers that even when something works out for me, I'm not sure that I did the right thing. And in this case, I'm pretty sure that I did not do the right thing and that it would have not panned out for me in the end had I won. But I've talked about this in part 42. I don't end up winning this case. And I end up figuring out that I was supposed to bring another action against the government, which was a petition for writ of mandamus. And that is the one that I do end up winning. But let's go ahead and move on now. Here we have my, let's scroll up. Here we have my notice of time limit to respond. I don't know why I did this. This is even weirder than the letter. And I think what I was trying to do was argue with them, but I didn't know really how to argue with a letter, because a letter is not a motion. It's just a piece of paper that's, it's not even really meant to go to the court, I guess. It's this whole, everything that comes from this struggle, this power struggle between myself and the Secretary of State is all very irregular. And this is just one part of that large irregularity. So I am stating that I've satisfied my obligation under Rule 4 by personally serving the Secretary of State. The Attorney General isn't complaining about me not serving the Secretary of State. They're complaining about me not serving them. So that's not really relevant. Next assertion is that I sent a certified return receipt letter of the original pleading and the copy of the summons to the AG's office. Okay, you can't do that under Rule 4. So again, this isn't relevant. I'm saying that I sent them a letter that would have worked under Rule 5 service, but when you serve the initial pleading, Rule 5 doesn't control. Rule 4 controls, and Rule 4 requires personal service by a third party. So again, I'm making an irrelevant assertion. It sounds in the principles of fairness and right and wrong and all of that, but I have a video explaining to my viewers why that doesn't work, and that's a video titled Fairness versus the Law. I don't recommend doing stuff like that because it can backfire on you. It didn't backfire on me in this case, but it can backfire on you in your case if you do what I did, which wasn't right. The next assertion here is I'm citing Rule 4, which is the initial service rule. I was just talking about this. So, service of the initial pleading. And this is just asserting that I served the Attorney General at the Secretary of State's office. No, I didn't. You can't serve the Attorney General at the Secretary of State's office. You have to serve the Attorney General at the Attorney General's office. So here is, okay. So the next line here actually goes into, wait, hold on a second. Let's go back to the previous one, which is number 3. And yeah, okay, so this is what I wanted to talk about in part 42, but I wasn't sure if that was when I had that little bit of conflict with the Secretary of State. So now that I've read this, now this does jog my memory, and yes, this was the occasion that I had a little bit of a conflict with the Secretary of State, and I'll go ahead and explain that now. What happened was the Secretary of State in Reno wanted me to drive to Carson City to serve their office in Carson City. And I thought that that was unfair because they had a satellite office in Las Vegas, and their satellite office in Las Vegas accepted service on the behalf of the Secretary of State. So I felt, hey, you've got an office in Vegas that takes service. Why doesn't your office in Reno take service? It seems to me like that's a little bit unfair. I felt like the desk staff were lying to me, that they were just trying to get rid of me. They were trying to make it so that I would go away. I don't know why they would think that, because I was pretty, well, they probably didn't know, my sort of personality. But throughout the year prior, I was really aggressive about litigating the case against my ex. And to me, I wouldn't just decide to quit just because I would have had to, have to drive 40 minutes to Carson City to serve the Secretary of State. But anyway, the way I dealt with it was by taking the petition and just sticking it to the glass. And I had to do that because the workers were all behind glass and they wouldn't come out. So they had said they're refusing service, they're not going to accept it, that I would have to go to Carson City, and if I didn't like it, too bad. And my response was, no, I'm just going to stick it to the glass. So I took a piece of tape and stuck the petition to the glass. Well, it wasn't me, it was my service processor, but I did go with her. I took I told her to do that, and she did, and that effectuated service on the Secretary of State. The next line here indicates that whatever it was that I did worked, because in a phone conversation with the AG's office, they indicated that, what I had done was fine with them. And I told them the same thing that I told the staff workers. I told them it's not fair that you take service in Reno, but you don't take service in Vegas. Now, the Attorney General's office isn't necessarily in control of the Secretary of State's office, but most of these government entities are really closely connected in the sense that they work together on these things. And so the AG's office probably called them up and told them, in the future, don't do that. Just take the papers. Don't make it a big deal that somebody went to the Reno office instead of the Carson City office, especially when the Vegas office takes papers. But anyway, all of this pertains to service of process on the Secretary of State. None of this pertains to service of process on the Attorney General. So this doesn't really work in my favor at all. I mean, it works in my favor that the judge accepts it, but it wouldn't have worked in my favor, I don't think, had it gone up on appeal. I don't think that the Supreme Court of Nevada would have sided with me if the Attorney General lost, or if the Secretary of State lost his case and they filed an appeal and they took issue with the fact that I didn't personally serve them with the petition. Next line here is that the Attorney General communicated with the court via letter, and they are fully aware of the lawsuit. Again, that's kind of a sort of an overarching fairness idea. It's not me complying with the service of process. It's not me complying with the rules or the statutes. So all of this stuff, it's reasonable, but it isn't consistent with the law, and that does become a problem if you end up going to an appellate court, because they are very strict about the law being applied correctly. Affirmation, which just lets the clerk of the court know that this document doesn't contain a social security number. List of exhibits, and that list of exhibits goes into the letter, which I already covered. So I'm not even going to go any further because we just went over that earlier in the video. Here we have another summons that was issued. I already had a summons issued. This is a second summons, and I'm assuming that this is for service upon the Attorney General, but I'm not sure. Affidavit of service attached to the summons indicating that I personally served the petition on the Attorney General at this address. That's not true because that's the Secretary of State's address. So I highly doubt. What I'm probably doing is I'm probably just counting them as one and the same. And I'm probably thinking, since I serve the Secretary of State here, the Attorney General is their lawyer, so that should count as me having served them as well. But they have a separate office that needs to be served. Now, I don't know this, and I'm doing the best that I can. Let me go ahead and scroll down. We have another affirmation, and this indicates, again, that this specific summons and affidavit does not contain a social security number. Moving on to the the certificate of service. Why did I do this? Oh, this is for the notice of time limit to respond. So this is just me communicating to the court that I served the notice of time limit to respond to the Attorney General by mailing a copy to their office. Well, okay, so you can do that under Rule 5. This is not the initial pleading. So yeah, if I mail that notice to them, that's considered correct under Rule 5. I'm allowed to do that, but it still doesn't solve the problem that they brought to the court's attention, which is that the petition itself wasn't properly served on them under Rule 4. So we're done with this certificate of service, and we will go to the court's order. The court is going to respond to this argument between myself and the Secretary of State. And the court has indicated that the petition for judicial review was filed on October 21st, consistent with the law. Pursuant to a letter from the Attorney General's office dated December 8th, the Attorney General was notified of this petition, and I'm assuming that the judge is basically saying, you eventually found out what was going on. You know about the lawsuit. And the next line here is that the petitioner must serve an opening brief within 40 days of this order. And okay, so basically the court is saying that service of process is good enough for him. And since it's good enough for him, we are going to commence with the briefing schedule. And the briefing schedule is just the dates and times as to when briefing is required. I'm required to serve and file an opening brief within 40 days. The government is required to serve and file an answering brief within 30 days after service of my opening brief. And then I may, if I choose to, file and serve a reply brief within 30 days of me having received their answering brief. Any party can request a hearing within 7 days after expiration of the time within which I was required to file a reply brief. And the court may or may not grant the request and will notify the parties if the court decides to do that. The reason why you're not always entitled to a hearing is because sometimes the issues that are before the court don't indicate that there needs to be a fact finding in a case. Sometimes there are no facts that are relevant to the case. It's just pure law. And other times there are facts, but they're not relevant, or there are facts that are asserted that the parties agree on. So there's no facts in dispute. And when these issues arise, the court will just render a decision summarily, which is to just render a decision on the paperwork without actually hearing, taking evidence and hearing testimony. And that is an option that's available to the court. If you want a hearing, you have to ask for one within 7 days, or it's not even considered. Certificate of service, and this is the court's administrative assistant indicating that she mailed the order that we just went over to me and also to the Attorney General. Going into the aftermath, I filed a notice of time limit to respond, another summons, another certificate of service, and all of those were free filings, so I incurred $0 in costs. The Attorney General filed a letter, and that's also a free filing, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. The Attorney General would have probably spent maybe 5 minutes to review the notice of time limit to respond, the summons, and the certificate of service all, together. Let's say another 5 minutes to review the court's order, because it's really just a scheduling order. There's not much to that. You just, put a ticker on your calendar as to when you're supposed to reply to an answering or to an opening brief. So I'll say another 5 minutes for that. So we're looking at 10 minutes now. And then we've got the letter that they prepared. It's a 1-page letter. It cites a single law, and it says, hey, I'm not, we're going to reply to you once you comply with this single law. So probably another 5 minutes there. So we are looking at 15 minutes in attorney fees. I'm going to go with the fact that they are not really using their best attorney for something like this right now. It's hard for me to think that they are, because I'm representing myself and I'm really stumbling around through the court system. So why would they put, a high-priced attorney on it? So I'm going to go ahead and stick with the $250 an hour, and 15 minutes, that's a quarter of an hour. So we're looking at $62.50 in attorney fees. As with my previous videos, if anyone has any questions, feel free to post something down in the comments below, and I will see you guys next time.